Welcome to Property Law 101. I am Professor Sara Bronin, and I created this series to help you understand property law. So we cover 4 questions in the series that I think are fundamental to property law. And today we are talking about this third big question, which is how do we use property and how does the law allow us to use property? One aspect of using property is making sure that you're using property in a way that does not infringe on your neighbor's quiet enjoyment. The elements of nuisance law, so relates to quiet enjoyment of property, the elements are covered in other videos. Today, we are going to talk about a few defenses to a nuisance claim. So if you're the defendant, what can you say to defend yourself against one of these claims? One possible defense is what we call coming to the nuisance defense. So the concept here is that the timing of competing land uses may be relevant in balancing the equities or in defending entirely against a nuisance claim. In other words, a plaintiff who is alleging a nuisance, if they came to a nuisance knowing that that nuisance is there, this will be held against them. So what does that mean? So let me give you an example, and in fact, an example that has been the subject of not just one, but many different cases. So consider a mine where mining activities created tremors that damaged neighboring houses, masonry, windows, pipes, the whole 9 yards. Those same tremors and mining activities created dust for neighbors. That constant shaking of the ground caused personal emotional damage, nervousness, sleeplessness, anxiety, and the houses themselves became unmarketable. So this seems like a classic nuisance, but then consider this one new fact. Consider the possibility, or the fact in this case, that the mine has been there since the 19th century. So even though there is all of this damage that is created for these plaintiffs, is it really right to reward them when they knew the mine was there? The mine would very likely have a coming to the nuisance defense. In many cases, the same factual scenario that allows a coming to the nuisance defense also allows for an estoppel defense. So again, think back to contracts law when you think about estoppel. If the nuisance was tolerated for some time, and if the offender relied on the ability to produce the nuisance or to have those activities that constituted a nuisance to the offender's detriment, then the nuisance can't be stopped. In our mine example, you might see, again, those facts leading to an estoppel claim for the mine. In nuisance law, we also see a defense common in torts lawsuits called the Eggshell plaintiff defense. So the idea here is that a particular plaintiff may not be the average or reasonable person. So for example, a glass blower might be an eggshell plaintiff if she complains about vibrations that are occurring because of a machinery tenant next door, vibrations that perhaps wouldn't be noticed by an ordinary person. Similarly, a drive-in movie theater might be an eggshell plaintiff where the patrons of the drive-in movie theater complain about a baseball field which shines lights at night next door. Nuisance law scoffs at hypersensitive uses or plaintiffs. So there are other defenses that somebody who's been challenged by a nuisance lawsuit might be able to bring, but I just wanted to give you with these 3 examples a sense that it is possible to defend against a nuisance action in certain circumstances. So with those 3 defenses in mind, I will leave it there. I'd love to hear from you, whether on Twitter or through my website, and I'll look forward to seeing you next time. Thanks.